Okay, 26 CR 57 is called the State of Texas versus Joseph Johnson. That's you? Here with your attorney, Mr. Kirk, and the state's attorney. You were charged with the second degree felony of aggravated assault causing serious bodily injury by punching a girl in her mouth. And let's see, he received, according to the grand jury, permanent disfigurement and trauma to the bottom row of her teeth. You had punched her multiple times in the face and head and caused her to lose consciousness. If convicted of such a crime, you are looking at 20 years confinement in prison. Where is this lady now? Do you know? I'm asking you a question.
No, I don't know.
I find out you have any contact with her or anyone on your behalf, you'll sit in jail until this is over with. Because the court sees this often. Too often. The male punches out the female, and then some reason the female changes her willingness to prosecute because something is being done in the background improperly and illegally. People trying to contact the poor victim and make them feel worse than they already feel for being traumatized. This court doesn't think much of males who punch out the girls. Not the way I grew up. And shame on anyone who does that. But two things happened. Either you punched her out or she just punched herself in the face until she lost consciousness and broke her teeth. Now, she's your wife, right?
Girlfriend.
Girlfriend. Okay. Well, who assaulted her if not you? I'm just.
No, I didn't know.
Okay. Well, didn't you go out and try to find out who did that to your girlfriend? I mean, isn't that important to you? You don't look at him. He didn't do it.
Judge, at this point, we're getting it.
I don't care what, he didn't have to answer. I can speak to him under the First Amendment all day long. But this court just does not tolerate people who mistreat others, especially people who have a legal relationship. You're supposed to protect the spouse, aren't you? Donna, that's what we learned, right? Well, I'm wondering who punched the poor lady out. Do you happen to help us with that? Don't you want to know? She's your wife.
Judge, he's announcing trial.
You don't care about finding out who might have done
Judge,
it?
he's announcing trial.
All right. All right. Is that right? Or is he going to speak for him?
I'm going to speak for him, Judge.
Are you going to go for trial?
Yes.
All right. Where's the lady now?
I don't think he knows.
Y'all can't have any contact. That's a court order.
Okay. I understand.
Nor anyone on your behalf can contact you.
I understand that part.
Do you need something? Tom's looking.
No,
Oh,
Your Honor. So
no, you don't know. Does the state know where she is? I mean, she's still alive, isn't she?
she is. We have an address for her, Judge. That I'll remain
But it's
quiet
not,
about it.
as far as you know, they're not cohabitating or contacting.
No, sir. And just to be real honest with the court, this is one I can prove with or without her. I don't know if the defense is thinking they can
Well, this-
prevail because she does
Is it-
cooperate.
The thing is about it, it just happens over and over again.
Yes, sir.
I find out that the people who have paramour type relationships in this often over and over again attempt to contact the victims, and that's just forbidden.
As I said, I can prove this without her. Her injuries are existent. The statements she made to medical treating folks are supported. The admissions that he made, we're gonna, if they want the trial, we'll give it to him. He'll lose his opportunity for a deferred.
I mean, anybody, does anybody feel bad for someone, a female who ends up with permanent disfigurement from an assault?
I do, Judge, and
I
that's
do
why
too.
I'm going to try it
No,
with or
it's
without her.
not, it's not rhetorical. It's trying to make a point. This is serious. Set for trial. And there are no deals. Move this one. We're going to move this fast, please. 26 CR 767 is now called is it Melzamira? Melzamira Henderson. Here with Mr. Dixler, your attorney and the state's attorney does. The defendant waive a formal reading of the indictment and the arraignment here. Can we proceed in summary? Yes. Harley Harrington, did you get a resetting? You can go. Yes, ma'am.
Takes a while.
She didn't have the plea in her queue. Don, did you send it over?
Jimmy hasn't, he hasn't signed it yet. I think he just up.
Okay. In summary, and the defendant waives a formal reading of this, we can proceed. In summary, this indictment alleges that on or about January 11th, 2026 in Jefferson County, Texas, you committed this third-degree felony of collision involving serious bodily injury. Do you understand what you were charged with here now?
Yes.
If convicted, you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
In this case, an agreement has been reached.
Yes, sir, for deferred adjudication, no fine, but restitution to be determined.
The agreement has been reached between the parties. You would be pleading guilty, but not found guilty. You would be placed on what we call deferred or unadjudicated probation, so long as you follow the terms and conditions of probation, which are normal and customary for this type of offense. This can be up to 10 years in length. If you do well, it can be shortened to 1/3. If you fail, probation could be revoked, and you could then be found guilty and then sentenced up to the full range of punishment. Do you understand what you're facing?
Yes.
How do you plead to this? Guilty or not guilty?
Guilty.
Or pleading guilty voluntarily. That is on your own free will, and because you are guilty.
Yes.
I'm going to show you what's marked here as States Exhibit
Yeah.
1. $14.
Yes.
Okay, I'll show you what's marked as States Exhibit 1. Did you sign that document?
Yes.
Understand it, discuss it with your attorney, or the contents are incorrect?
Yes.
States Exhibit 1 tendered,
No.
without objection admitted.
Yeah.
Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with, and in fact, it's been read to you. You've read it. You were guilty of the crime charged, and the lesser included offenses. You are giving up your rights to a jury trial, or the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer and all truths will help you got your States Exhibit 1, part of the record for all purposes, pre-sentence reports.
Yes.
I'm going to follow this agreement if nothing further. I'm going to find, Ms. Henderson, that you are mentally competent to enter your guilty plea, and it is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But this court is going to postpone or put off all finding of guilt so long as you follow the terms and conditions of probation. Where the probation officer is going to go over all of those with you, make sure you follow them. Again, as I said before, if you fail, then your probation could be revoked. You could then be found and sentenced. You don't want to foul up your record here. So do well. Also, there are going to be several terms and conditions of probation. Most of those are the kinds of things all of us have to do, like commit no crimes, avoid injurious habits, things like that. But in your case, we're going to order a defensive driving class to be taken and paid for by you. Although that is a win-win for you.
And then so
You'll learn how to be more conscious about your driving. Your insurance will go down because of successfully taking this class. So it helps you financially.
Yeah.
This is for 10 years. And again, like I said, you do well, it can be shortened to 1/3, which is 3 1/3.
So,
And also restitution, we have TBD, to be determined. I'm going to, you are going to be responsible for any damage or loss to a victim caused by your wrongdoing, but we don't know how much that is. We're going to, probation officer will look into it, figure it out, and we'll come back later. And, or I will sign a supplement. And you've got to help put those people back in the position they were before they were injured as best we can. You can't undo pain, but you can pay for, if it's your responsibility, you can't pay for the costs for their damage that was caused by your wrongdoing here. That's how you fix mistakes. Make a mistake, then you fix it, you move on and do that. Okay, please see the probation officer. Thank you.
Who is this?
Your Honor, here's.
Oh, okay, well, I don't know what I do with this. Is this for your file, I think, maybe? Well,
Oh, wait, please.
Thought it was twenty-four.
I don't know, I'm some off business. I don't,
Normally,
it doesn't,
Change this my lord.
yeah,
yes.
Yeah, that's all.
okay, then, there is no deal. We're going to trial and, this is, third degree felon. It's also enhanced with this 2012 conviction. So he's looking at, 20 years with, no probation available. And that's what we'll do. Set this as soon as possible. That's you?
Yes, one.
Okay, and Mr. Kirk is your attorney, right?
Yes.
Okay, oh, we said that. You were charged here in 26 CR 510 with the third degree felony of tampering or fabricating with physical evidence. Unlawfully carrying of a weapon, intentionally only concealed a weapon, and there's a Glock. And if convicted, this is a third degree felony. And you are facing no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Does the defendant have any prior criminal history? No?
That's my word, Judge. We have an offer. She's.
Fix this. This is fixable. Yeah, you just make a mistake. Okay. Welcome. We all make mistakes. Fix it and move on with your life and do better. What else? It's April 1st. It was indicted. Couldn't have been typed with any smaller print. There is no way that.
I understand.
Don't challenge them, Judge. They'll find a way.
This computer Zoom. Chance. Mike's been an offer. She just wants to get that video. That's all she wants to do.
Correct.
There's a unique aspect that needs to be the disabled driver.
You don't see this often. Normally, people just don't toss handguns out their vehicle. They normally keep them. You're going to do that. You don't want to do it when the policeman is right behind you, watching evidence. She was arrested for public intoxication as well. Is that right?
That's right. Yes.
That's here.
I think that's accurate, Judge.
Yeah, that's actually done.
Yes.
That's public intoxication, or intoxication isn't voluntary intoxication is not considered a defense in the laws of the state of Texas. So can't say, well, I didn't know what I was doing because I was intoxicated. If it's voluntary intoxication, it's the fault. You gotta take responsibility. So today, what do we set for announcement?
Yes, sir. She wants to watch the video. I think we're gonna be able to resolve this one, but she wants to watch the video and go with the discovery judge.
Okay, I got 4 weeks. Is that good? Thanks. Good set.